The morning he said it was a Monday in February, which I remember with the specificity of a person who has spent a career knowing that the details are the difference between a case that holds and one that doesn't. It was 7:18 in the morning. The temperature was 41 degrees. We were on Oleander Drive heading toward the bridge, the same route we had taken every weekday morning for 6 months, and Connor Holt was in the passenger seat of my Buick, doing what Connor Holt did every morning of those 6 months, which was talking on his phone with the window up and his eyes on the screen in his hand, and his body turned at the slight angle that signals to the driver that this conversation is a private one, and the driver is a mechanism rather than a person. He had been on the phone with his business partner Warren Briggs since we left Diana's house on Bradford Court at 7:05. 13 minutes of a conversation that I had been hearing from the driver's seat, not every word, but enough, in the way that you hear a conversation when the person having it is 2 feet to your right and believes you are not listening. I was always listening. I had been listening every morning for 6 months. It was of those 6 months the thing I did with the most consistent attention and the least visible effort. At 7:18 on that February Monday, with the bridge coming up ahead of us and the Cape Fear River reflecting the winter sky beneath it, Connor said into his phone, in the tone of a man wrapping up a logistical point before moving to the next item, "The old man driving my wife's family around doesn't suspect a thing. By Friday, everything transfers." I kept my hands on the wheel at 10 and 2, which is where they had been since we left Bradford Court. I kept my speed at 38 miles per hour, which was the appropriate speed for Oleander at that hour. I kept my eyes on the road in front of me, which is where the eyes of a man driving a car are supposed to be. I did not react. I did not change my breathing. I did not look at him. I drove him to the office building on South College Road, where Connor Holt's commercial real estate firm occupied the second floor. I pulled into the drop-off area. He said, "Thanks, Leonard," already putting his phone back to his ear as he opened the door, and he was gone through the glass doors of the building before I had fully stopped. I drove home to the house on Forest Hills Drive. I went inside. I sat at the desk in the study. I took the small digital recorder from my jacket pocket, and I plugged it into the laptop, and I copied the morning's recording to the folder I had been building since the 3rd week of September. Then I picked up the phone, and I called Sandra Polk. She answered on the second ring. I said, "Sandra, I need to move today. The timeline is Friday." A brief pause, the pause of a woman who has been waiting for this call and is shifting into the mode the call requires. She said, "Tell me exactly what he said." I told her. She said, "Leonard, I'll have the emergency motion filed before noon. Call Marcus Felder at his personal number right now. Before anything else, we need the forensic accountant moving on this today." I called Marcus Felder. I started the day that ended Connor Holt's plan 4 days before Connor Holt was ready for it to end. My name is Leonard Mercer. I am 71 years old. I live in Wilmington, North Carolina. I drove my son-in-law to work every morning for 6 months because he told my daughter his car was being serviced and he needed help, and because I offered, and because what I had already suspected by the time I offered made the offering the right thing to do. He thought I was doing him a favor. I was gathering evidence. Welcome to True Story. Hit that subscribe button and drop your city in the comments below. We read every single one. Quick thing before we get in. Skip ahead if you just want the story, no pressure. But if something in what I just told you reminded you of a situation in your own family, I want you to know about Ironclad. It's the system I wish every family had before the Friday arrives when everything was supposed to transfer. Legacy Shield, Boundary Blueprint, Family Protection Vault. 75 pages of the exact tools for protecting what your family has built before someone who has access to it decides to move it. Half off today at $8.99. Link and QR code on screen. Completely skip it if you want. Otherwise, let me take you back to September. I practiced corporate law in Wilmington for 31 years. I am going to say that simply and without ornamentation, because the simplicity is the point. 31 years. Not real estate law, not family law, not criminal defense. Corporate law, which is the discipline of understanding how entities are structured and how assets move within and between those structures, and what the documentation of those movements looks like, and, critically, what the documentation looks like when the movements are not what they appear to be. I retired in 2018. I had built Mercer & Associates into a 12-attorney practice with clients across the commercial and manufacturing sectors of the Cape Fear region, and I had sold my equity interest to my partners at a valuation I considered fair and that reflected 31 years of what I had built there. I retained of counsel status for transitional purposes. I moved into the house on Forest Hills Drive, which Margaret and I had bought in 2009, and that she had arranged exactly as she wanted it in the 3 years between the purchase and her death in 2012, and I have not moved a significant piece of furniture since she died, because the arrangement was correct, and she was right about the arrangement, and I have not found a reason to revise a thing that was correct. I had 2 children. Philip was 44, lived in Wilmington, worked in construction management, and called on Sunday mornings, and stopped by the house on Thursdays, in the specific rhythm of a son who has decided that showing up without occasion is the occasion. He was steady and practical, and had his mother's instinct for when something was not right, which had led him to call me, in August of last year, with the specific, careful phrasing of a person who wants to say something about a family member without saying it directly. He had said, "Dad, have you noticed anything with Diana and Connor lately?" I said, "Tell me what you're seeing." He said, "I don't know exactly. There's something in how Connor talks about money that's been bothering me. The way he frames it. Like everything is already decided, and Diana just doesn't know about it yet. Like everything is already decided, and Diana just doesn't know about it yet." I had been noting the same thing for several months by that point, in the way that a 31-year corporate attorney notes things, which is quietly and specifically, and in the back of the mind, where the pattern recognition that the career builds runs continuously, whether you invite it or not. I had been watching Connor Holt for 3 years, since Diana had brought him home in the spring of 2020 and described him as someone special, and I had been finding, in the watching, the specific combination of qualities that my professional experience associated with a particular type of person. Connor Holt was 41 years old and ran a small commercial real estate firm in Wilmington called Holt Capital Properties, which occupied the second floor of a building on South College Road and employed 4 people, including himself. He was engaging and specific, and had the social fluency of a man who understood that impression management was a professional skill, and who had developed it into something that was effective in most rooms. He spoke about his business with confidence, and about Diana with warmth, and had been, in the 3 years of the marriage, the kind of son-in-law that it would have been easy to like without examination. I examined things. It was what I had done for 31 years. What the examination produced, in the first year of watching Connor, was not evidence of wrongdoing. It produced the pattern that precedes wrongdoing, which is a different and more useful thing to have, because the pattern gives you time. The pattern I was watching was the pattern of a man who had organized his life around access to things that were not his, and who was in the process of determining how to make that access permanent. Diana was 38. She had worked as an interior designer since graduating from NC State in 2008, had built a client base in Wilmington across 8 years, and had been operating her own design firm since 2016. The firm was not large, but it was solid and growing in the specific way of a practice built on referrals from satisfied clients, which is the most reliable form of growth in the service businesses, because the client who refers has already solved the trust problem that advertising cannot fully solve. She owned the firm. She had not incorporated Connor into it. She had a joint personal account with him that she used for household expenses and kept her business accounts separate. The joint personal account was what concerned me, not its existence, which was ordinary, its balanced trajectory, which was not. I was watching Diana's financial picture from the position of a father who had helped her structure her initial business accounts in 2016, and who had, in that process, established a familiarity with her banking relationships that she had not revoked, because there was no reason to revoke it, and because Diana trusted me in the way that a daughter trusts a father who has been helpful without being controlling for 38 years. I was not accessing her accounts. I was noting what she mentioned in conversation and cross-referencing it against what I knew of the typical trajectory of a household at her income level. What she mentioned in conversation in 2022 and into 2023 was that things felt a little tight. Not an alarm, a mention, said in the specific offhand way that people mention things they are not quite ready to examine directly. Tight. The water pressure in the kitchen was lower than it used to be. An easy thing to say that means something more is happening, and the person saying it is not ready yet to name the more. I noted it. I did not push on it. In August, Philip called with the conversation about Connor's framing. I listened, and I thought about the tightness Diana had mentioned, and I began, in the specific way a retired corporate attorney begins a thing when he has decided it is time to stop watching and start acting, to move. I called Sandra Polk. Sandra had been Wilmington's most effective family law attorney for 22 years, and I had referred clients to her twice from the corporate side, when corporate matters had disclosed family law dimensions, and she was thorough and direct, and had a specific intolerance for people who used legal structures to harm the people they were supposed to protect. I called her in late August and I described, in the careful language of a former attorney who has not lost the habit of precision, what I was observing and what I believed was building. She said, "Leonard, if you're right about the trajectory, we need documentation, not supposition, documented transactions, account records, communication records if they exist." I said, "I understand what we need." She said, "Do you have access to any of it?" I said, "Not yet, but I'm going to offer to drive Connor to work." A pause, then, "Why?" I said, "Because his car is 23 years old and I've been waiting for it to become an issue, and if I offer at the right moment he'll accept, because accepting is easier than refusing, and Connor takes the easier option when he can." She said, "And while you're driving him?" I said, "I'm going to listen." Connor's car developed a transmission problem in the first week of September. I know this because Diana mentioned it at a Sunday dinner at the house on Bradford Court, and I knew the car's history because Philip had helped Connor with a different mechanical issue the previous spring and had described the vehicle's general condition with the specificity of someone in construction who understands what deferred maintenance produces over time. I offered to drive Connor to work the following Tuesday. I said it over dinner, directly but without emphasis, in the tone of a father-in-law doing an ordinary thing for an ordinary reason. I said my schedule was flexible in the mornings, and it was no trouble if he needed it, while the car was being sorted out. Connor looked at me with the brief assessment of a man calculating the offer. I had noticed across 3 years, a specific tell in moments of assessment, which was a half-second pause before the social register of warmth arrived. The calculation happened in the half-second, and the warmth covered it. He said that was really generous of me, that he didn't want to impose. I said it was genuinely no trouble. He said he'd take me up on it, just until the car was handled. The car was not handled for 6 months. Connor rode with me every weekday morning from September through February, a total of 114 mornings. And in that time he was on his phone for approximately 90 of them, and looked at me directly approximately 4 times, 2 of which were to say thank you when getting in, and 2 of which were to say thanks when getting out. I had understood by the end of the first week that the phone calls were to Warren Briggs, whose name Connor used often enough for me to attach it to the voice I could hear on the speakerphone during the 2 mornings in October when Connor held the phone at an angle that let the sound carry further than he realized. I had the name, I had the cadence of the conversation, I had the general shape of what was being discussed, which was business, but business with a specific urgency and a specific direction that pointed always toward the same destination, which was the consolidation of assets under Connor's control. The recorder went into my jacket pocket on the 3rd morning. I want to be precise about this because precision matters. The recording was legal under North Carolina's one-party consent statute, which permits a party to a conversation to record that conversation without the knowledge of the other parties. I was present in the vehicle. I was a party to the environment in which the conversation was occurring, even if Connor was not directing the conversation at me. I was not a party to the call itself, which is a distinction that the law draws carefully, and that Sandra and I had discussed before I started recording. Sandra had said, "Leonard, the recordings are likely admissible in a civil proceeding as contextual evidence of intent. Whether they meet the standard for criminal fraud evidence depends on what's in them." I said, "I'll find out what's in them." What was in them, across 114 mornings and approximately 11 hours of audio, was a picture. The picture assembled itself across the months, the way a picture assembles in the developing solution in a darkroom, which is slowly and by degrees, and with each pass revealing more of the detail, until the full image is visible. What I could hear in the recordings was the vocabulary of a plan. Not every word, not every specific, but enough vocabulary to understand the architecture of what was being built, which was the vocabulary of account structures, and transfer timing, and threshold amounts, and the specific legal language that a man uses when he has had a conversation with an attorney about how to move assets in a way that happens before the person who shares those assets has time to respond. Diana's name appeared in the recordings occasionally, not often. When it appeared in the context of timeline, which is the specific context in which a person's name appears when the person is an element of a plan rather than the purpose of it. By December, I had enough to call Sandra and describe the architecture. She listened for 40 minutes, asking questions that moved through the recording content with the precision of a family law attorney who has encountered this pattern before and knows which questions to ask to fill the gaps. At the end, she said, "Leonard, what you're describing is a systematic preparation for fraudulent transfer of marital assets prior to a divorce filing. The account movement pattern you've documented is consistent with what forensic accountants call pre-bankruptcy planning applied to a marital estate, which is the process of moving assets into structures that the non-owning spouse cannot access before the divorce is filed, so that the equitable distribution process has less to distribute." She said, "If Friday is when he executes the transfers, we need to move Thursday at the latest, ideally Monday." I said, "The Monday will be determined by what he says." She said, "Are you going to know when the Monday is?" I said, "He'll tell me. He tells me everything. He just doesn't know he's telling me. He told me on a Monday, in February, at 7:18 in the morning, on Oleander Drive. The old man driving my wife's family around doesn't suspect a thing. By Friday, everything transfers." I dropped him at the office building on South College Road. I drove home. I sat at the desk in the study. I copied the morning's recording. Then I called Sandra. Sandra filed the emergency motion for a temporary restraining order on marital assets at 11:47 that Monday morning. The TRO application cited a specific and documented pattern of pre-bankruptcy style asset movement consistent with intentional dissipation of marital estate in anticipation of a divorce filing, supported by a 6-month audio record and a preliminary forensic accounting review that Marcus Felder had begun at 9 o'clock when I called him. Marcus Felder was 53 years old, had been a certified forensic accountant in Wilmington for 20 years, and had the specific quality that forensic accountants develop over 2 decades of finding things that people have tried to hide, which is that he did not assume he understood the full picture until he had looked at every document, and he did not communicate the partial picture as though it were the full one. He called me at 2 in the afternoon with what he had found in the 4 hours since I had given him the account access records Diana had provided when Sandra explained the situation to her at 1 o'clock. "Diana, I need to tell you about that conversation." Sandra called Diana at 12:30. I know the timing because Sandra told me afterward, and because Diana called me at 12:47, which was the call I had been both preparing for and dreading since September. Not because of what it would contain, because of what it meant for my daughter to receive the information inside it on a Monday in February, when she had gone to work that morning expecting an ordinary week, and was about to discover that the week she was inside had been building for 18 months. Diana was 38 years old, and had her mother's composure, which was not the composure of a person who does not feel things, but the composure of a person who feels them completely, and manages what she does with them. Margaret had been the same. The feeling was full and present, and the management of it was precise, and the two things coexisted because she had watched them coexist in her mother across 38 years and had absorbed both as the correct way to move through the world. She called and said, "Dad." That was the first word, just "Dad," in the specific voice that tells a father the whole shape of what his child has just been told, without any of the words of it needing to be spoken. I said, "I know. I need you to listen to me, and then I need you to go with whatever Sandra tells you to do." She said, "How long have you known?" I said, "I've been watching since August. I've had documentation since September." She said, "You drove him every morning." I said, "I drove him every morning." She was quiet for a long time. I did not fill the quiet because the quiet needed to be what it was, which was a person understanding something about her life that is going to take longer than one phone call to fully understand, but that begins in a specific moment. And this was the moment, and I was going to let her have it without rushing through it. She said, "What do we do now?" I said, "You let Sandra and Marcus do their jobs. You provide whatever access they ask for. You do not contact Connor, and you do not change any of your behavior today in a way that indicates anything has changed. Go back to work. Finish the afternoon. Can you do that?" She said she could. She did. She was, as I said, her mother's daughter. Marcus called it too. He said, "Leonard, I want to be direct with you, because I think directness is what this situation requires." He described what he had found. In the 18 months preceding the Monday in February, Connor Holt had moved a combined total of $214,000 from joint accounts and from accounts in Diana's name that he had gained access to through the marriage into 3 separate business accounts held by Holt Capital Properties. The movements had been structured below the threshold amounts that typically trigger automatic review, which is the specific pattern that indicates the movements were not casual but planned. He had also, Marcus said, structured a secondary account at a financial institution in Raleigh, in a business name that was not Holt Capital Properties, but that shared Connor's social security number as the primary account holder. This account had received 6 transfers in the preceding 4 months, totaling $88,000. The receiving entity was registered as a sole proprietorship in Wake County. $214,000, plus $88,000 in the secondary account, $302,000, over 18 months. I sat at the desk in the study with Marcus's voice in my ear, and I thought about the tightness Diana had mentioned in passing in 2022. Things feel a little tight. The water pressure in the kitchen, the easy mention of a thing she was not ready to name. She had been feeling it. She had not known what she was feeling. He had been bleeding the accounts for a year and a half while driving to work in her father's car and saying, "Thanks, Leonard. Thanks for the ride," never once looking at the man who was listening to everything he said. Marcus said he would have the full forensic report ready by Wednesday morning. Sandra called at 4. She said the TRO had been granted. All accounts connected to Connor Holt, Holt Capital Properties, and the Wake County entity had been frozen effective immediately, pending a full forensic review and a hearing on permanent injunction scheduled for Thursday. She said the notification would be served to Connor at the office on South College Road between 4 and 4:30. I thought about Connor in the second-floor office on South College Road, about the moment the process server arrived, about the specific moment when a plan that has been built carefully over 18 months encounters the specific obstacle that it was not built to encounter because the builder did not know the obstacle existed. He did not know I had been recording. He did not know about Marcus Felder, or the forensic timeline, or the Wake County entity being visible to someone who knew how to look for it. He did not know about Sandra, or the TRO, or the frozen accounts. He did not know that the old man driving his wife's family around had spent 31 years as a corporate attorney in this city, and had, in those 31 years, encountered this specific pattern in a business context more than once, and knew exactly what it looked like and exactly what it required to stop it. He had called me the old man. He had said I didn't suspect a thing. Philip called at 5:15. He said Diana had called him and told him some of what was happening, not everything, enough. and he had gone to Bradford Court and was with her, and asked if there was anything he needed to do. I said, "Stay with her tonight. Make sure she eats something. Let Sandra handle the rest." He said, "Dad, did you know this whole time?" I said, "I knew something was building. I didn't know the full shape until this morning." He said, "How did you get the recording?" I said, "I drove him to work every morning for 6 months." Philip was quiet for a moment. Then, he said something I did not expect him to say, which was nothing. He simply breathed, the specific breathing of a person who is processing something that is both worse than they expected, and more complete than they expected, and in the breathing I could hear him understanding what his father had been doing in that car every morning for 6 months, and what it had cost to do it in the quiet way, without saying anything, without reacting, maintaining the flat, unreadable surface of a man who is simply doing a favor for his son-in-law, and has nothing else on his mind. He said finally, "You're something else, Dad." I said, "I learned a long time ago that the most useful thing a lawyer can do in a situation is listen. Most people stop listening when they think they already know what they're hearing." Connor Holt did not stop at the office on South College Road Thursday morning, when he realized the accounts were frozen. He drove to Bradford Court in the transmission-troubled car that had not been serviced in 6 months, despite his claim, and he knocked on the door of the house where Diana was living, with the 2 cats she had named after fonts, which was the kind of specific detail about my daughter that I loved, and that Connor had always found impractical and vaguely absurd, in the way that people find impractical the things they do not understand. Diana did not answer the door. Philip did. Philip was 6 feet 1 inch tall, and had spent 15 years in construction management, and had the physical presence of a person who has spent a professional lifetime outdoors, managing large projects and large people who do not always want to do what the project requires. He opened the door and looked at Connor with the specific patience of a man who already knows what the conversation is going to be, and has decided on the tone he is going to hold throughout it, regardless of what Connor does with his. He said, "She's not here. You need to call Sandra Polk's office." Connor said something. Philip did not report what Connor said, and I did not ask, because the specific content of what Connor said in that moment was less important than what happened next, which was that 4 minutes after Philip opened the door, Connor got back in the transmission-troubled car and drove away. Diana came out of the kitchen when the door closed. She had been there the whole time, in the kitchen with her coffee, listening to her brother manage the door without being asked to manage it. She said, "Is he gone?" Philip said he was gone. She said, "Good. Do you want eggs?" He said yes. She made them eggs and they sat at the kitchen table for an hour, talking about other things, which Philip said when he called to report was exactly what she had needed. The ordinary texture of a Tuesday morning in her kitchen with her brother and the cats named after fonts. I thought about that image for a long time after Philip described it. Diana making eggs on a Thursday morning after the week she had been having. The ordinary thing after the extraordinary week. The kitchen and the brother and the cats and the eggs. That is what you are protecting when you listen carefully for 6 months in a car on Oleander Drive. Not the accounts, though the accounts matter. The ordinary morning. The ability to make eggs in your own kitchen with your brother and not be afraid of what Friday is going to bring. The forensic accounting process ran for 11 weeks. The TRO became a permanent injunction at the Thursday hearing. The Wake County entity was dissolved by court order and its assets repatriated to the marital estate. The $302,000 that Marcus Felder had documented was recovered in full through the civil proceeding. Connor's attorney, a competent and visibly uncomfortable man from a Raleigh firm who had clearly been given a case with less solid ground under it than he had been told to expect, negotiated a settlement that Sandra described as the most thorough recovery of pre-bankruptcy-style dissipation she had seen in 22 years of family law practice. Diana filed for divorce in April. The equitable distribution was handled on the foundation of Marcus's forensic report, and Sandra's work, and the 6 months of recordings from the Buick on Oleander Drive. Connor Holt's commercial real estate career in Wilmington did not survive the forensic accounting findings, becoming part of the public court record. The professional associations that govern commercial real estate in North Carolina have specific standards regarding fiduciary conduct, and the court record did not leave much room for ambiguity about whether those standards had been met. I will not catalog what followed, because it followed naturally from what the record said. What I want to tell you instead is about a Sunday in May. Diana came to the house on Forest Hills Drive on a Sunday in May with a pot of the she-crab soup that Margaret had made on Sunday afternoons in the fall and winter, and that Diana had learned from her mother and had been making since she was 16. She brought it in the specific ceramic pot that Margaret had bought at a gallery on Princess Street in downtown Wilmington in 2010, and that Diana had asked for specifically when we divided the things in 2012, which I had understood was about the soup rather than the pot. She made the soup, and we sat at the kitchen table where Margaret had sat and I had sat for 30 years, and we ate and talked about the design firm, which was doing well in the spring market, and about Philip's youngest, who had said something at school that week that was so specific and so characteristic that it made us both laugh when Diana repeated it, the kind of laughter that arrives when something is genuinely funny rather than performed. At some point she set down her spoon and looked at me across the kitchen table and said, "Dad, 6 months." I said, "6 months." She said, "Every morning." I said, "Every morning." She said, "You never said anything. To me, to Philip, to anyone. You just drove him." I said, "Saying something before I had what we needed to say it with would have warned him, and he would have moved faster, and we would have had less time and less documentation. The useful thing was to listen." She looked at me for a moment. She said, "How did you know something was wrong before you even started driving him?" I said, "Because you mentioned things feeling tight in a way that didn't match what I knew about your income. And because Philip called me in August and said something about how Connor framed money. And because I spent 31 years watching how people who are planning to move assets talk about money when they think no one is paying attention. They use a specific vocabulary, a specific urgency, a specific direction. Connor was using all of it. She said, "You recognize the language." I said, "I recognize the language." She was quiet for a moment. Then she said, "Mom would have recognized it too, wouldn't she?" I said, "Your mother could read a room faster than any attorney I ever worked with. She recognized things before they had fully formed. I'm slower. I needed the audio." Diana smiled. It was the specific smile of a person who has come out the other side of something that cost them significantly, and who has found, in the coming out, something solid underneath the cost. She said, "I have a client meeting Thursday, and I need to pick up fabric samples in Raleigh on Friday. I'll be fine." I said, "I know you will." She said, "You knew before I did." I said, "I knew what I was watching. You just hadn't had a reason to watch it yet." She picked up her spoon. We finished the soup. The Sunday afternoon went on in the specific way of Sunday afternoons in a kitchen, where good food has been made by someone who learned from the person who used to make it in this same kitchen, in this same pot, which is the continuity that is not dramatic and does not require description beyond its existence. I cleaned up after she left. I put the ceramic pot back in the cabinet. I looked at the kitchen the way Margaret had arranged it in 2010, which I had not changed, and I thought about 31 years of listening to what people said when they thought no one was paying attention, and what it had produced across those years, and what it had produced on a Monday morning in February, on Oleander Drive, when a man said by Friday, everything transfers into a phone held 2 feet from the ear of a retired corporate attorney who had been waiting 6 months for exactly that sentence. He had called me the old man. He had said I didn't suspect a thing. I suspected the thing. I built the case. I made the call. That is what 31 years teaches you. Not how to fight loudly, how to listen until you have everything you need, and then how to make the one call that changes everything before Friday. If this story stayed with you, drop a comment below and tell me which moment hit you the hardest. Hit that like button, subscribe if you are not already here, and I will see you in the next one. One last thing. Feel free to skip entirely, but if this story reminded you of someone in your own family, who has been moving quietly in a direction you can feel, but haven't been able to name yet. Ironclad is built for that moment. The legacy shield, the boundary blueprint, the family protection vault, the exact tools for protecting what your family has built before someone with access to it decides to use that access. $8.99 today, half off, link and QR code on screen right now. Get your family's documents locked down tonight. True Story uploads every week. Subscribe and hit the bell so you never miss one.